Okay, so now it's recording. Great. So welcome everyone. I see that there are still a few guests coming into the meeting. While we admit them to the webinar, I will start introducing today's session. Great, I see many friends and colleagues joining us. So as you know, today we're going to have what we call a rapid reaction webinar on the 2023 update of the OECD guidelines for multinational enterprises, now renamed OECD guidelines for multinational enterprises on responsible business conduct with the latest update. We are basically we aim at giving an overview of what are the main changes, the key developments that this update has introduced. I guess most of you are aware of what the OECD guidelines are. Of course, they are recommendations jointly addressed by the OECD governments to multinational enterprises to address adverse impacts associated with business activities on, as the OECD says, people, planet, and society, and to enhance also business contribution to sustainable development. And you are probably also aware of the fact that the OECD guidelines are supported by an implementation mechanism at the national level, the national contact points, now called National Contact Points for Responsible Business Conduct. Of course, the guidelines were first introduced in 1976, so a long time ago. But they were since updated 4 times, if I'm not mistaken, until 2011. And indeed, the latest update in 2011 had been a very crucial update, because that's when the OECD guidelines came to include a whole human rights chapter fully aligned with the UN Guiding Principles on Business and Human Rights. However, since then, of course, many things have happened. And the OECD, I think 2.5 years ago, started this process to introduce a new update of the guidelines after over 10 years. And according to the OECD, this new update aims at responding to urgent social, environmental, and technological priorities facing societies and businesses. So today, in about 1 hour and 15 minutes, we will briefly present and discuss some of the key novelties introduced by this update. And we will do so with the help of some experts and friends who were kind enough to accept this invite on a relatively short notice and in a period in which most of us are eager to go on holiday. So thank you once again to the speakers who joined us. By the way, as usual, I failed to introduce myself. I am Chiara Macchi. I am an assistant professor at the law group of the Wageningen University. And I will be sort of chairing this webinar, but I will also give my comments on the update after the other speakers have made their interventions. So in order of appearance, we have Catherine Booth, researcher and policy advisor at OECD Watch. And then we have Laura Inigo Alvarez, assistant professor at the Nova School of Law. And finally, Olena Uvarova, associate professor at Yaroslav Multinational Law University, and Marie Sklodowska-Curie, researcher at the Wageningen University. Once again, thank you all for joining us. And I will start by giving the floor to Catherine. Catherine, of course, works at OECD Watch, and OECD Watch was at the forefront of the process that led to the revised version of the OECD guidelines. So I would like to start with her and asking you, Catherine, first of all, to talk a little bit about the role that OECD Watch played throughout the process. And then, of course, give us your general appraisal of the outcomes of this process. You have the floor, Catherine.
Thank you. So OECD Watch is the institutional stakeholder for civil society to the OECD Investment Committee. So throughout the negotiation process, we represented civil society's voices. The process itself was 2.5 years, so it's been a really long process. But we've been advocating for this update for longer than 2.5 years. We started thinking about it in 2016 and committing to undertake to advocate for the update in around 2019. We weren't the only group advocating for this update. Of course, we also have our colleagues from the trade unions and also the business at the OECD. So OECD Watch represented civil society, but trade unions and business were represented by these two other bodies who also engaged in advocacy and provided recommendations to the investment committee on the update process. So it really kicked off in November 2020 when, after OECD Watch and others' advocacy, the OECD, the Working Party on Responsible Business Conduct, agreed to undertake this stock taking exercise. So basically, they sort of looked at the system, saw what the gaps, what the weaknesses, what the strengths were, and they considered whether the guidelines remained fit for purpose. So throughout this process, OECD Watch was making written and oral submissions to the OECD. We were consulting with our members, we were consulting with other civil society experts, and we were pointing out both the strengths but also the many weaknesses of the guidelines. So we were happy in mid 2021 when the draft stock taking report was released by the OECD, and basically this acknowledged that there were gaps and that these gaps needed to be filled. There was also several other reports by the OECD, but really hard negotiations for the updated text took place from June 2022. So that was almost a year ago, when the OECD agreed to what they called a targeted update of the guidelines. So it was called a targeted update because they really wanted to narrow the focus to what really needed to be changed in the text. So since almost a year ago, we've again been engaging with our members, with civil society, but also with OECD itself, but also OECD governments, to provide our input on the text that should, in our opinion, be updated and was updated. We didn't itself. We just provided recommendations. So we were not itself like a state. We were not conducting negotiations. We were just providing input on the negotiations and the many iterations of draft text that we were provided. So there were two public consultations that the OECD conducted, and the most recent was at the start of this year. It took place in January and February 2023. And there we also provided our recommendations. I think over 200 submissions were received from all stakeholders, 50% from civil society. And basically that public consultation focused on what was called the public consultation draft. And really we were advocating for the strengthening of the text. The text itself was updated on the 8th of June 2023. So this 2.5 year process came to an end with what OECD Watch considers to be, on the whole, strong text. It's important as a general background to realize that the OECD guidelines are sort of two parts in one. The first part is standards for enterprises, and the second part is recommendations for NCPs, national contact points, which is what Chiara mentioned is the implementation mechanism for the OECD guidelines. So in relation to the first part of the text, the standards for enterprises, OECD Watch is generally very pleased with the text. And with the second part, we are less pleased. But in relation to the first, there's really strong text. I'm really excited about the text on climate change and the environmental harms and environmental concerns. I believe another speaker is going to go into that in more detail, so I won't go into that much more. But basically, climate change is recognized in the text. The Paris Agreement is recognized in the text, and enterprises have responsibilities in terms of climate change. There's also mention of just transition in the text, which is new. just transition in terms of both leaving fossil fuel projects and entering new renewable energy projects. Meaningful stakeholder engagement is also discussed, and another speaker, I believe, is going to speak about that, so I won't go into that, but it's really been strengthened. Meaningful stakeholder engagement being a key step of due diligence, very important for civil society and OECD Watch. The text also recognizes that harms occur against human rights defenders, and companies should take steps to prevent those harms and reprisals occurring against defenders. And that was something that OECD Watch pushed for strongly in the text, and we're pleased to see that that was included. Our colleagues at the Trade Union Advisory Body also, alongside us, pushed for stronger text in the employment chapter about respecting all workers' rights, not just employees' rights. So companies need to respect the rights of all workers in their value chains. This is a really important development. Another positive development is the inclusion of animal welfare in the standards for enterprises, and this is really new and was accepted by the OECD states. So companies should basically treat animals according to good welfare standards. So this was also really positive. So they're the standards, but now moving to part 2, which is the recommendations for NCPs. We were less pleased with that, primarily because we had pushed for stronger wording. We had pushed for should language. NCPs should or must do this. But what was implemented was guiding languages. NCPs are recommended to do this and this. And because OECD Watch has been this year analysing NCPs and the OECD guidelines for 20 years, it's our 20th birthday this year, we are very aware of the problems with NCPs. And in order to remedy those problems, the requirements need to be strengthened for NCPs. But in our view, there were no requirements, it was more recommendations. Determinations of compliance and non-compliance with the guidelines are really important for OECD Watch and civil society. They're a really important mechanism for remedy. But this, for example, was more of an acknowledgement that NCPs can do this, not that they should or must do this. So in general, this is our issue with the second part, is that the text wasn't strong enough in our view. But I think I'll leave it there, Chiara. Thank you.
Thank you so much. Thank you, Catherine. And this is a very useful overview, already planting some seeds for discussion, and we will go back to some of these issues later on, I'm sure. And indeed, perhaps with Laura, we can go a bit more into depth regarding stakeholder engagement. That is, of course, a key component of the due diligence process, and this one of the aspects that seems to me has been generally recognized as having been really strengthened in the new edition of the guidelines. So, Laura, could you tell us a bit more about that?
Thank you, Chiara, and thanks so much for the invitation. Yes, thank you for the kind invitation in this timely webinar, because I think this year we are witnessing a number of developments at different levels. So we have the updates now in June of the OECD guidelines, but in parallel we have the process of the draft directive on corporate sustainability due diligence. And one of the important aspects of the due diligence process, but not only that, of the remediation process, is the question of how to ensure meaningful stakeholder engagement. And I agree with Catherine that this is one of the issues that has been strengthening in the guidelines. Again, this is also discussed in parallel in the draft directive on whether it's aligned with international standards on business and human rights, the UN guiding principles, but not only instruments on business and human rights, but other instruments that focus on the protection of vulnerable and marginalized groups, the question of human rights defenders, so how to update the guidelines to be in line with these international standards. So again, we need to remind this, the principles already in the UN guiding principles. The question that meaningful stakeholder engagement has been also mentioned as one of the key goals in the UNGP's roadmap for the next decade that was published by the UN Working Group on Business and Human Rights. And there has been a number of additions and updates in Chapter 2, the general policies, the chapter on human rights, and the chapter on the environment. Again, I also agree with Catherine on the fact that there has been important additions in the part on the guidelines, substantive part of the chapters, whether on the part on the implementations, the question of national contact points. I also feel that the update has been weaker in terms of how to promote these engagements. And later I can mention something about that. So the first issue that we have is that the previous version, the 2011, already called for stakeholder engagement, but this updated text goes farther, providing more guidance into what engagements or meaningful engagement should be, and in particular the idea that it should be two-way, conducted in good faith, responses to stakeholder views, and also timely, accessible, appropriate, safe, and the idea to remove these potential barriers to engage with stakeholders in position of vulnerability or marginalization. So this requirement is in line with other previous guidelines, like the OECD due diligence guidelines from 2018 that already offer more detailed guidance. So the idea of two-way communication, so the question that the enterprise and the stakeholder freely express opinions, share perspective, and listen to alternative viewpoints, the question of good faith of both sides, so that the enterprise engage with genuine intention to understand how relevant stakeholder interests are affected by this activity. So trying to understand this not as a tick box approach, but as a really genuine dialogue and understanding on how human rights impacts could affect right holders and then other right holders, how they can participate in the different process of the due diligence. So not only in the identification, but throughout the whole process of due diligence. The question of be responsive as well. So this also involves the timely provision of all information needed by the potential impacted stakeholder and right holders to be able to make an informed decision on how to the decision of the enterprise could affect their interests and be ongoing, of course. So this is not a one-time exercise. This means that the engagement with stakeholders continues throughout the life cycles of an operation or an activity of the enterprise. We also, if you can go to the next ones, we also find the question of meaningful engagement, stakeholder engagement in the question of responsible disengagement that I believe probably, I think Olena will touch upon that. So this is also another key issue. And we have seen this in the question of areas affected by conflict when there is the issue of disengagement. So we also need to take into account how to involve stakeholders in this process and how to measure the adverse impacts of the decision of leaving. So this is also another addition in the guidelines. Talking about another issue that Catherine mentioned is human rights defenders, because this is one of the key stakeholders in the process. And the previous versions, the 2011 version, did not mention human rights defenders. So it's important to see that now the chapter on human rights call on enterprises to pay special attention to impacts, among others, on human rights defenders, who might be at a heightened risk of heightened risk due to vulnerability, marginalization, and other circumstances. So this is an important update in the guidelines. There are also new expectations on the issue of reprisals with regard to the standards for enterprises, and later in the question of implementation procedures for governments. So again, here in the general policies, the chapter now calls on enterprises to refrain from and take steps to prevent reprisals against any person or groups that may seek to investigate or raise concerns about the potential or real adverse impacts associated with the enterprise's operations, products, and services. And there is also a definition of what reprisal might, which form they could take. And here we also see that they include the question of not only physical attacks, but intimidation, surveillance, strategic lawsuits against public participation. That has been one of the measures taken against human rights defenders and other relevant stakeholders. So I think this is an important update. However, in relation to reprisal, there is no explicit reference to human rights defenders. Also, there is no reference, for instance, to the UN Declaration on Human Rights Defenders. And there is still not much guidance for enterprises on what the steps they need to take to promote this idea of safe space when individuals and groups could raise concerns. And again, looking at the process of the draft directive, we see also the question that the version of the Commission does not include human rights defenders explicitly, although we see like the report from the European Parliament does. So I think this is a good sign of the updates of the guidelines. If we see, for instance, talking about due diligence legislation, the other national legislation do not also refer to the question of human rights defenders, although they contemplate the issue of stakeholder engagement in the provisions. Another important point, I think, is the question of mentioning the issue of vulnerability and intersectionality, because here one of the updates is to call on enterprises to pay special attention to adverse impacts on individuals who might be at heightened risk of due to marginalization, vulnerability, and the question of intersectionality. So how human rights due diligence need to consider the distinct and intersecting rights related to individuals, individual characteristics of impacted people. This is also included now in the human rights chapter. And also the chapter on the environment also mentions the idea of meaningful stakeholder engagement. That is also another addition when related to communicating regarding environmental impacts, and also reflects the idea of paying special attention to situations of vulnerability, marginalizations, and persons possessing special rights. In the part of the question of the implementation procedures, like Catherine mentioned, I agree that I think the text is still a bit conservative, because as she mentioned, it's still more recommendations, and then it's up to the governments whether they will take this improvement and recommendation into consideration. And one of the things is the question of the institutional arrangements of national contact points. Now there are references that the government should consult stakeholders regarding decisions that may significantly affect the NCP institutional arrangement. Also, they refer that the idea to keep and develop meaningful relations and engage with representatives from business, work organization, NGOs, and other interested parties. But again, and this could be done, for instance, in the question of establishing multi-stakeholder advisory bodies. But we see that in terms of the institutional arrangements, NCP, the majority of them are still composed of members of ministries, And some of them have advisory bodies that include different stakeholders, but still many NCPs do not have these bodies. So I guess this is still one of the weak points. The sense now there is a reference that regarding a specific instance, the NCPs are encouraged to develop their case handling procedure in consultation with stakeholders, but still I think that the language is a bit soft. And there is also an addition about the question of reprisals. So how NCPs need to take appropriate steps to address reprisals against a party to a specific instance. So I see here a good potential on how the guidelines have been updated. But on the side of the NCPs, I think we need to work more in order to then to become a really effective mechanism. And for instance, the question of remediation that is still not in line and still causes many challenges for right holders and different stakeholders. So maybe I can leave it here.
Sorry. Okay, yes, I am unmuted. Thank you so much, Laura. I have now unshared your PowerPoint, I think. Yes, perfect. I see myself frozen, but as long as you can hear me, fine, I guess. Okay, let me do it like this. Yes, perfect. Then let's move on to Olena, who will add a further layer to the discussion. So, Olena, I would like to get your observations and in particular ask you whether the revised guidelines, in your opinion, contain adequate recommendations for multinational enterprises in relation to situations of conflict.
Yeah.
You have the floor, Olena.
Yeah, thank you. Thank you very much, Chiara. And step back to the previous speaker, to Laura. Could we share your slides in chat, because it seems that it was frozen and we saw just the first slide and participants are interested to have the whole presentation. So if it's possible to share via the chat. Yeah, and if I would like to address the concept of responsible disengagement, and in this context, of course, to talk about responsible business conduct in situation of conflict. And the new guidelines clarify that companies must act responsibly when considering disengaging from a business relationship. And of course, it's not a new concept, because we had previously the idea, of course, of responsible disengagement as a last resort, and but of course the last events, the last situations, I don't mean just the war in Ukraine, but many other situations related to the conflict in Myanmar and in Sudan and many others. Of course, they raise the question of correlations between responsible business conduct in situation of conflict and responsible disengagement. And when we talk about OECD guidelines, guidelines identify responsible disengagement as a tool of leverage over business relationships that are failing adequately to address identify adverse impacts. And in this regard, enterprises are encouraged to build leverage by, among other things, communicating in advance to the business partner the possibility of the enterprise's disengagements if they don't meet expectations around responsible business conduct. And I also should say that I appreciate very much, and I believe that many participants of today's webinar appreciate very much this the table that was developed by OECD Watch to compare OECD guidelines, in particular related to responsible disengagement and different. Different editions of the draft of Corporate Sustainability Due Diligence Directive and recommendations of OECD Watch how the draft of directive could be developed in line with OECD guidelines, and I totally support. And if participants, some participants are not familiar with this paper of the OECD Watch, we will share in the chat as well. So, but actually, of course, as I said, it's not a new idea about the responsible disengagement. And also when we talk about responsible disengagement, we should remember that other OECD documents, OECD sector recommendations, they also include recommendations about responsible disengagement, and some of them are much more specific than OECD guidelines on responsible business conduct, because they address to the more specific situations, and in particular OECD due diligence guidance for responsible supply chains of minerals from conflict affected and high risk areas. This guidance gives as I said, much more specific provisions for companies, or the OECD due diligence guidance for responsible supply chains in the garment and footwear sector, includes general guidelines of disengagement and also specific recommendations related to occupational health and safety, and trade unions and collective bargaining, and also there are specific recommendations for financial institutions and so on. And also, of course, as Laura already mentioned, the general concept of responsible disengagement is connected very much with the idea of meaningful stakeholder engagement, and actually responsible disengagement should be based on the dialogue with all relevant stakeholders that could be potential impacted with disengagement. And actually the vivid case of importance of responsible disengagement is actually a Telenor case in Myanmar, and again it's also a connotation to the important role of national contact points, because the complaint based on this case was actually was prepared, and because of this situation, because the Telenor contact raised a question about was this disengagement responsible or not. But also, I would say that as a general concept, of course, it's a very important concept, and also OECD guidelines mention the situation of conflict, but without they are not going to details, and one positive thing that I could mention that OECD guidelines mention the concept of enhanced human rights due diligence, and there is also a terminology case because I'm not sure that when we use two different terms, enhanced human rights due diligence and heightened human rights due diligence, is actually a good case because I would prefer, to develop the concept. No, probably I would prefer heightened human rights diligence just because we already have the guide which was developed by UNDP team and UN Working Group for Human Rights, and it was published in June 2022 on heightened human rights due diligence. And actually the key idea of heightened human rights due diligence that in situation of high risks for human rights, companies should assess and should identify and assess and address to human rights risks, not just those risks that company could create for human rights, but also those risks that high risk situation creates for human rights and what is the impact of company to this situation, not to make this situation worse for human rights. And actually OECD guidelines also is talking about such kind of situations that when we have more high risks for human rights, we need to have enhanced human rights due diligence, but actually it's the same as heightened human rights due diligence. And of course, it's about also when we talk about conflict situation, it's also about international humanitarian law should be one of the focus of attention of companies. And so that's why I also see that, and again, OECD Watch in their recommendations to address to the draft of European Union directive on corporate sustainability due diligence is also actually talking about we need to develop standards which will be agreed to each other, and but it also means that we need to agree terminology. And my probably final point that actually responsible disengagement in OECD guidelines, it seems that this concept is addressed to quite daily situation because the terms of disengagement from business relationship is used, and all text is addressed to the situation when a company has a leverage and could impact on this business relationship. But in reality, we see that the application of this concept is much more complicated and much more broad. What I mean? I mean that responsible disengagement is applied also for responsible exit, and not exit from business relationship only, but exit from the market, exit from the country. And and it's much more complicated relationships, and it's not just about the leverage of company in in concrete business relationship, but it's actually about the whole environment. And we had last week the podcast with Ekaterina Dekala about actually in particular about responsible business conduct in non-democratic regimes, and is it actually in what moment we should expect from companies that it should exit from this country, but stay in this country in a responsible way in some cases could also have positive impact. No, so it's not easy case just to say you should exit in a responsible way, but probably you should stay in a responsible way. So it's very different situation, and yeah, so and also in the conflict situation, we saw in Ukraine that many international companies they stopped to operate in Ukraine, not just because the war started, but probably in many cases, much more responsible conduct would be to stay in a responsible way. No, so it's so I would say that we need to take into consideration also responsible exit, responsible stay, and responsible return, because when the conflict, for example, ends, companies are considering to return to some territories, and it should be done also in a responsible way. Yeah. So it's it's my overview and my I would say feelings about the text of updated guidelines.
Thank you so much, Olena. This was really interesting. And I also wanted to apologize with the participants because apparently the previous PowerPoint could not be correctly visualized. So as mentioned, you can get in touch either with me or Laura, and we can send it to you. But also, like, the slides basically made reference to the relevant sections of Chapter 2 on general policies, Chapter 4 on human rights, and Chapter 6 on the environment concerned with stakeholder engagement. So you can also easily retrieve those bits. Thank you, then, Olena, for concluding this round of comments. I will, however, add my own comments now because you all mentioned some aspects of this 2023 update that is also relevant for the environmental dimension of the OECD guidelines. And in particular, now I would like to focus more closely on climate change and how it is now dealt with under the revised version of the guidelines. Wait, maybe I can put myself in evidence here if I manage. Yeah. Okay, so as you might know, the previous versions of the guidelines did not really mention climate change. Even the 2011 update did not explicitly mention climate change. However, this doesn't mean that the guidelines did not include any relevant principles. They did. Proof is the fact that in recent years, the NCPs in their specific instances have started to interpret in a very interesting way certain principles of the OECD guidelines in a sense that also underlines the climate change responsibilities of corporations. So even before the 2023 update, we find, for instance, some specific instances filed with the NCPs that dealt with for instance, the disclosure of accurate information on greenhouse gas emissions on the part of the companies, but also on their responsibility to reduce emissions. So we have already mentioned the fact that, of course, the guidelines include a chapter 6 on the environment, but of course this must be read also consistently with other chapters of the guidelines, including on disclosure or on consumers, for instance. So just to make an example, even before this year's update, we had a complaint filed against British Petroleum before the UK's NCP, and this was about what we may call an instance of greenwashing. So basically, British Petroleum was accused of misrepresenting the corporation's efforts towards a transition to sustainable energy supply, and this was through its advertising campaign. The complaint did not reference the Chapter 4 on human rights, but it did allege a breach of the guidelines chapters on environment and on consumer interest. So based on these two chapters, the claimants in this case, while the petitioners alleged that BP was not really disclosing accurate statements in its own advertising campaign, and actually it was indeed misrepresenting its own energy operations as sustainable. And the case was initially accepted by the NCP, indeed, because these issues the NCP thought were sufficiently material and substantiated. Then, of course, the BP withdrew its advertisement campaign, and so the petition, the specific instance was ultimately discontinued. So we did not have, in this case, filed by Client Earth, a final statement finding BP in breach of the guidelines. But this already highlights how the NCPs, even before this year's important update, were starting really to develop a certain sensitivity towards the theme of climate change, greenwashing, and even in relation to substantive emission reduction obligations for corporations. And a very interesting case in this respect is a specific instance filed against ING Bank in the Netherlands at the Dutch NCP, in which basically the bank was deemed to have failed to disclose its own indirect emissions, so the emissions linked to its own lending portfolio, and also was accused of failing to put in place an accurate system to assess those emissions and reduce them in line with the Paris Agreement. And the Dutch NCP actually underlined that indeed, in this case, financial institutions have a clear responsibility, even in the absence of specific international standards and guidelines as to how to measure indirect emissions. They have a clear responsibility to develop a methodology to assess Scope 3 emissions, and to also have a plan in place to reduce them in line with the Paris Agreement and with international goals for the reduction of greenhouse emissions. So it was already clear before this year's update that corporations could not get away with completely dodging their own climate change responsibilities based on the fact that the guidelines did not explicitly mention climate change. So already there was this, let's say, this ongoing development, at least led by some more forward-looking NCPs. But it's important to note that the current update, of course, is way more explicit about the responsibilities of corporations. First of all, the updates provides a non-exhaustive list of environmental impacts, and this list has as its first point climate change, and then it also mentions biodiversity loss, degradation of land, marine and freshwater ecosystems, deforestation, and so on. But climate change is indeed considered as one of the main environmental impacts that really clearly fall within the scope of the guidelines. Companies are called to establish and maintain a system of environmental management. We already have had this provision before, but it contained a lot of where appropriate. So for instance, establishing measurable targets in the previous edition was only required where appropriate, whereas now the guidelines are way more straightforward in mandating the establishment and implementation of measurable objectives, targets, and strategies for addressing adverse environmental impacts. And these targets should be science-based and consistent with international commitments. So already this general provision has been strengthened. And then, of course, the commentary to Chapter 6 on the environment is extremely innovative because for the first time there is an explicit reference to the UNFCCC and to the Paris Agreement. And importantly, there is an emphasis on risk-based due diligence and prioritization. This is expressed in much greater clarity than in the past. The fact that the main factor orientating a company's due diligence choices must be the severity and likelihood of the adverse impacts required, which means that you will need to prioritize the most severe or likely of the impacts. And this risk-based due diligence provision is extremely important in relation to climate change, of course, because it means that for many companies, climate change will need to become a priority in due diligence policies and processes. And then the guidelines emphasize the role of companies in achieving a just transition, where just transition requires recognizing not only the environmental impacts per se or the climate change impacts per se, but really the interlinkages between environmental and climate impacts and the other matters covered by the guidelines. So health and safety, human rights, impacts on workers and communities, access to livelihoods, land tenure rights, and so on. And the companies are explicitly called to contribute towards net zero greenhouse gas emissions. And this is a very straightforward and clear recommendation that was absolutely absent from the previous version of the guidelines. And in many cases, the guidelines explicitly say that this will require a reduction of greenhouse gas emissions consistently with internationally agreed global temperature goals and with best available science, in particular the science reviewed by the IPCC. Among other things, therefore, companies are called to establish short-term, medium-term, and long-term science-based mitigation targets. And here there are two important specifications to make. So, first of all, such targets must take into account Scope 1, Scope 2, and Scope 3 emissions. The guidelines say, to the extent possible, based on best available information, Scope 3 greenhouse gas emissions will have to be taken into consideration in establishing such mitigation targets. This is important because this is indeed an ongoing discussion. In the Netherlands, the Shell judgment called on Shell to indeed cut its own greenhouse gas emissions. And it specified that the company has a clear obligation of results to cut Scope 1 and 2 emissions, but also a best effort obligation to try and reduce its Scope 3 greenhouse gas emissions. And these are also the emissions, for instance, that are linked to consumers. So the emissions produced by the consumers who use the company's products. So the OECD guidelines in this case are really forward-looking and include all emission scopes. Also, they affirm that enterprises should prioritize eliminating or reducing sources of emissions. So carbon credits or offsets may be considered as a means to address emissions, but only as a last resort. So that the priority should be given to actually eliminating or reducing emissions. This is, if you think about it, is pretty much in line with the UN Guiding Principles on Business and Human Rights when they say that a company cannot offset its own negative impacts by putting in place positive actions. First of all, companies need to act and stop or mitigate their own negative impacts. You cannot just ignore those impacts and make up for them through positive voluntary actions in other fields. And this is a bit the approach that the OECD guidelines are taking to the climate change responsibilities of corporations. So this is also a very important development, I will say. These are the main issues concerning climate change and the OECD guidelines. It is perhaps interesting to note that at the moment they are way more complete and specific than the Commission's proposal for a due diligence directive. Perhaps the version that is more in line with the OECD guidelines approach is the position the negotiating position expressed by the European Parliament that is definitely the most advanced when it comes to the climate change provisions of the draft directive. So I will stop here and perhaps we can continue the conversation for a few minutes in the Q&A. So let me see if the participants have any questions, they can put them in the chat. Let me open now the chat to see. Okay, so at the moment we don't have any questions. If you want to, feel free to ask questions. In the meantime, perhaps I'm also curious to ask perhaps Catherine in particular, because you also mentioned that OECD Watch is particularly happy about the chapter on the provisions concerning climate change. So I would like to ask you whether you have any comments on this, if you agree with me or if you have noticed something different.
Yeah, no, it was a really, really good summary. Thank you so much for your presentation, Chiara. We agree with everything you're saying. I also agree with you that the EU Parliament's position is most closely, well, it's the preferred text in our view, also because it most closely aligns with the OECD guidelines, which we see as the, it's the most comprehensive standard on responsible business conduct and particularly on, enterprises' climate change responsibilities now. So I agree with you there. About the climate change, it's funny, we're in a limbo period at the moment because the guidelines as of the 8th of June this year apply to companies. They have responsibilities under the guidelines. But it's a tricky period because companies may not be aware of these responsibilities yet. We, civil society and business and the trade unions need to inform companies about their new responsibilities. When can an NCP complaint be filed under the new guidelines? Maybe, a company should be informed about this first. So it's a funny period. I expect in 6 months to a year, we'll start seeing many complaints filed under the new text of the guidelines about enterprises' climate change responsibilities. And also, as you mentioned, Chiara, their environmental responsibilities, biodiversity, pollution, habitat loss, all of these things, enterprises should conduct due diligence to prevent and mitigate. But Laura, perhaps you have something to say.
No, I actually just wanted to ask a question to maybe rather also Chiara or Catherine in relation to the issue of this development in the OECD guidelines into climate change and the environment linked to the work of the NCPs. Because now that the text has been updated, and then already there were cases linked to that, but now we have a more complete text. For the work of the NCPs, do you think we need more expertise on the side of also the NCP, how they're going to deal with future complaints? Because we see like more developments and there is also need for how to quantify, how to individualize. So do you think it could be also one of the cases for the part of the improvement? And I also see a question about the NCP's legal authority for people that are new. So they are recommendations, so they are not enforceable, but there is a possibility of follow up. And then there is maybe Catherine can tell more about the question that whether there could be consequences in the sense that whether the government could establish some negative consequences, whether the company don't want to engage. But this is something that has not been included in the updates.
Yeah, Catherine, maybe you can have the floor and then I will also have some comments.
Yeah. Many of these cases that come to NCPs are really complicated, and they're getting more complicated because there are no other forums for remedies. So some really hard cases become before NCPs. And as I think Laura mentioned, these NCPs are just often a couple of government officials who have no expertise in requirements, responsibilities of companies and the Paris Agreement and, what are scope 3 emissions, So expertise is really important in NCP complaints, and in our view, expertise is required. The guidelines actually, I believe there was an update which said that there was a focus in the guidelines in the OECD has put focus on the need for NCPs to be better resourced. And that just means funding, but that also means expertise. So the guidelines, the new text actually recognize that there's this problem of lack of funding, but also lack of expertise. In OECD Watch's view, often the best NCPs will bring in experts to advise on complaints. And that is a double-edged sword, I guess, because of course that's the best option available, what is ideal, but that also requires resources for an NCP to be able to do that, and often they don't do that. But this is going into another sort of side note of problems with NCPs. But I definitely agree that expertise is essential in these quick, tricky cases. And then there was a question about consequences. I can't see the question right now, but in general, as Laura just said, NCPs are not judicial bodies. They can't require companies to do anything. They can't force them to engage in mediation because it's essentially a mediation body. But in very, very limited cases, NCPs have power. They don't have power. I shouldn't say that. They don't have power. NCPs have the ability to recommend or make a suggestion to their government to have negative trade benefits. What does that mean? Basically, the NCP can say, well, and this is a new update, I should say, in the new text. In this case, the NCP didn't engage in good offices, or they had bad faith when they were engaging, or they, in fact, the NCP can make a determination of non-compliance with the guidelines. And based on these recommendations, the NCP can say to their government, well, this company didn't do this in this case, and we recommend some sort of consequence against them, or we would advise that you treat them differently. And for companies that have strong external faces, so they engage in trade outside the country, this might mean that they have negative trade benefits. They might not be recommended. They might not be the preferred choice of partner with a government. But I must emphasize that this is extremely rare. It is only one or two NCPs which have the ability or the possibility to do this. And the new text of the guidelines recognize this possibility of NCPs to make these recommendations to their governments, but that was all. It was a recognition and it wasn't a requirement. Thank you.
Yeah, yes, indeed. I think really a big issue when it comes to the NCPs is the fact that there are so many huge differences between one country and another on the level of staffing, of resources that these that these bodies can make use of. I remember I looked into it a few years ago because I had to write a chapter about it, and I remember some NCPs did not have money to organize a workshop or to attend conferences or to train their own personnel. So, as Catherine said, of course, now companies must be informed about the OECD guidelines update, and one of the tasks of the NCPs is actually also to spread awareness of the guidelines among the relevant stakeholders. But of course, some NCPs simply don't have the resources to do that. Let me answer also a question about the climate due diligence provisions. There was a question by Madalina asking whether it is an obligation of result or conduct. So, of course, the directive and the OECD guidelines cannot be directly compared because the OECD guidelines are only recommendations. However, we can, so first of all, the draft directive as drafted by the Commission does not fully integrate climate change as part of the process of due diligence. And this is, in my opinion, a big weakness of the Commission's proposal. The European Parliament proposes something stronger in this respect. The Shell judgment, so it's just a court decision in one European country, so it's important, but of course it cannot, it does not bind corporations other than Shell in that specific lawsuit. But I think it's interesting because for the first time it gives a rule on how companies should approach their emissions reduction obligations. So direct emissions must be cut, and this is an obligation of result according to the court, whereas scope 3 emissions should be reduced, but this is expressed by the court as a best efforts obligation. So the court says if you want to achieve the mandated cut, which is, if I remember correctly, 45%, you cannot achieve that without also addressing your scope 3 emissions. So you should put steps in place to the effect of also reducing scope 3 emissions. But then again, this is expressed as a due diligence obligation and not as an obligation of results. The OECD guidelines they don't express themselves in an obligatory language because they are not a directive, they are not a legally binding instrument, but still they do say that mitigation targets should be put in place. They must be science-based. And these mitigation targets must, in any case, account for scope 1 and 2 emissions. So let's say, to put it simply, direct emissions. But to the extent possible, so slightly nuanced language, based on best available information, also scope 3 emissions. So there is, again, a sort of nuancing between the different emission scopes. Let me see if there are other questions. I don't know if the other speakers have spotted other questions that they would like to reply to in the meantime. Sorry, I'm just scrolling to the chat. Yes.
There's a question from Ben. He asked, do you think NCPs will accept claims against business for acts or policies carried out prior to the development of the new standards? So yes, they will continue to accept complaints filed under the 2011 version of the guidelines. My earlier question about the limbo period was businesses need to know about the 2023 guidelines in order for a complaint sort of to be filed against them. That's not necessarily true. They don't need to know about them, but it is, it's best that they do. And the aim of the next, 6 months for everyone, as Laura points out, not just civil society, business and trade unions, but also NCPs, is to promote the guidelines. And as Laura says, there are many seminars that the OECD and also NCPs are holding to promote the guidelines.
Yeah. it seems to me that we have answered all the questions in the chat. I hope so. Yeah, I think we did well. So I don't know if you have any last comments or reactions to what we have said so far. Of course, like the ambition was not to be absolutely comprehensive in these comments, but at least to give you an overview of the main developments that the new version of the guidelines have introduced. You know, when we talk about the specific instances and the final statements of the NCPs, of course, as we have said, these are not judicial decisions. They are not as binding as a judicial decision. And of course, resorting to the NCPs does not mean in any way being barred, being prevented from bringing a lawsuit if this is necessary or useful. But the NCPs can indeed contribute to interpreting what due diligence should look like for corporations, especially in new fields such as climate change, in which there is still too little guidance, too little clarity about the responsibilities of corporations. So it is a process of interpretation, of clarification of standards that can also, to some extent, influence other policymaking processes, for instance, at the European Union level. I think I'm not mistaken if I say that the European Parliament, and as in part also picked up from the work of the OECD and of some NCPs in formulating its own position, that is quite an advanced position on some aspects of the new due diligence directive. So. And of course, for petitioners, it can be a less costly, less time-consuming way to initiate a conciliation procedure, or at least reach a final statement on the part of the NCP on a case in which they believe that their own rights and interests have been harmed by a corporation. So indeed, as we have said today, perhaps the implementation part of the guidelines remains the slightly weaker part, even after this update. But because now we have clearer standards, at least the most forward-looking and most well-reserved and best resourced NCPs could now have further stamina and a stronger ground to promote advanced interpretations of the guidelines. So I would thank all the speakers of today's session, and thanks to the public for participating and allowing us to go more in depth with your questions. This webinar is being recorded, so it will be then posted to our website, to the website of the Wageningen University, and I will also disseminate it via our social media when it's ready. Thank you so much. Enjoy your summer break and hope to see you the next time. Bye-bye.